Good morning and welcome to FirstService Residential's annual Florida Legislative Update. My name is Tony Calici. I'm special counsel to FirstService Residential, and I'm happy to be your moderator for our session today, along with Travis Moore of Moore Relations. Travis is a friend and longstanding legislative partner with FirstService Residential. Thanks for being with us today. Travis, good morning.
Good morning. Thank you, Tony. I'm very excited about this. We have a lot of great information to cover. Session just ended on March 8th. And so we're really just hitting this at the very early outset. And a wonderful panel that you've put together. So I'm really excited about this. Thank you.
Thanks, Travis. As you mentioned, March 8th was the day the 60-day session ended. And lots of things happened with relation to community associations, vacation rentals, Estoppels, Condo and HOA reform, and more. And we're going to go through it in detail today. We've got a great panel, as Travis mentioned. We're going to look at some of the bills that passed, some that didn't, and their impact on community associations. Note that we are recording today's webinar. Within a few days, it'll be up on our website. You can review it if you need to, or refer to anybody else you think might benefit by watching it. Also, we share another valuable resource, which is our legislative alert. That'll be up on the website as well. We have to note at the outset that what we do today is not meant to be specific legal advice. We have some great legal experts with us, but it's very important for you to engage your own attorney so that you can understand how these changes in the law impact your community. So with that in mind, I'd like to introduce our panel today. Again, three very experienced, well-respected attorneys in the field of condominium community association law. First, Elizabeth Bowen of the Siegfried Rivera firm. Elizabeth, good morning.
Good morning. Thank you so much for having me. Really enthusiastic about participating in the panel today.
Thank you. Next, Jeff Rembaum. Jeff, longstanding community association practitioner and a principal in the K. Bender Rembaum firm. Jeff, good morning.
Morning, everybody. Looking forward to a great presentation this morning.
And last but certainly not least is Bryony Swift. Bryony's with the Becker Polikoff, the Becker lawyer firm. Bryony, welcome.
Thank you so much for having me, Tony.
Well, Travis, busy session. We talk about March Madness, and a lot of people are talking about, the NCAA tournament. But in our world, March Madness certainly is this year was the conclusion of the legislative session, which was a very active one, to say the least.
Absolutely. And with it being an even number year, 2024 session started in January, ended in March. So we just, like I said, got through it. There were a number of bills, I think over 75 bills that we were following and monitoring and tracking and working very closely that impacted community associations of all stripe and whether it be co-op, condo, HOA, timeshare, mobile home, et cetera. So a number of those passed. And so unlike some years where this webinar update would be a very short affair, we will definitely be hustling to get it all in because there was just a lot that has passed. I will just make also the notice or the caveat that none of these bills that have passed have yet gone to the governor. We anticipate that they will go to him soon. There's no direct date that has to happen. But once he does receive it, then the clock starts and the governor has 15 days to sign it, veto it, or it becomes law without signature. The majority of the bills that we are going to be talking about today would have a July 1 effective date. So that's important to know and to notate. There's some pieces in there as we get and the panelists talk about the meat that have some other dates that'll be triggered in, but the effective date of the new law, should these get signed, and I anticipate that they will get signed. There's one that we'll talk about, vacation rentals, briefly, that it still may be a little bit of a toss up, but I think I think it'll get signed, and certainly I think the rest of them will. I just want to mention that if you have any questions, we appreciate all the questions and the feedback that we get. Use the Q&A a feature there at the bottom of your Zoom screen rather than the chat. It's easier for us to then monitor through the program the questions as they come in. We'll try to address most of them. We can kind of notice if the same one question or we start getting multiple inquiries about the same topic, we'll answer it that one time, of course. And then also if we don't get to them all, we can follow up, capture that, get answers to you. And then again, as Tony mentioned, this recording will get put out for you all to see. And we'll have someone with the FirstService team follow up with you if we don't get to your question. So Tony, I think we are ready to get started. And there was a large condo reform bill that passed. There was a large HOA reform bill that passed. So those of you in HOAs, sit tight. We'll be getting to you. Let's start with the condo one. And I'm going to kick this over to Jeff to kind of go through and hit the highlights for us, and then the panel to weigh in, and then we'll discuss it. The only thing I would mention is that this is pretty much, I'm referring to this as instead of a sequel to the things that you'd heard about over the last couple of years, Senate Bill 4D, Senate Bill 154, and the issues that came out, building safety reserves, all of those. This is more, I think, of a prequel. This could have been done many years ago, probably should have been done. And it's one of these things that will kind of reform the entire system, but doesn't deal directly with the SIRS and the milestone inspections and that kind of thing. So, Jeff, why don't you start us with that and kind of lead us through?
Absolutely. Nice
Thank
to see everybody this morning. Thank you all for joining us. House Bill 1021. For those of you that are asking about how you track the bills and such, go to the Florida Senate homepage. You can Google it. You can type in any bill number. Right-hand side, the little button you push, track this bill. Next thing you know, every time something happens on that bill, you will receive an email. It literally is that easy to track a bill. So for those that are asking on the chat channel, that's how you do it. I haven't seen this many legislative changes across the board in, I don't know, 15, 20 years maybe. It's been a whirlwind tour. So congratulations to both Tony and Travis for actually surviving this year's legislative session. I put out a lot of articles. Many of you know Rembaum's Association Roundup, Community Association News you can use. If you want to receive it in your inbox, I'll be doing in-depth analyses on the legislation later. So you've got my email address if you want me to add you to that list. All right, first and foremost on House Bill 1021, today is highlights only. We cannot get into the minutia today. We're only doing highlights. And here are the highlights. We're going to talk about milestone inspections. We're going to talk about new condominium definitions. We're going to talk about electronic voting, kickbacks, deficient insurance allegations, official records with clarity as to emails and faxes, facilitation of record inspection, websites, use of record requests, checklists that must be provided by the association, criminal punishments now on the table, folks. Boards required to meet 4 times a year for the sole purpose of, you guessed it, letting owners ask questions about particular subjects. We're going to talk about new board member certification requirements. We're going to talk about how you're guilty until proven innocent. Yes, in the United States of America, as a condominium association board member, you can be guilty until proven innocent. We're going to talk about election tampering, hurricane protection, statute of repose, huge change, wonderful consumer protection for everybody. You're going to love it. SLAPP suits, huge expansion on prohibition of SLAPP suits, division jurisdiction expanded, new CAM requirements if we have time, and as a bonus, lucky strike extra, for those of you that are reading the bill analyses, I know that you are, there was an erroneous statement in the staff analysis to House Bill 21 regarding structural integrity reserve studies and pooling, and the drafter of the analysis wrote in there that pooling was not allowed last year. Nowhere has anybody said in writing from an official standpoint, not the law, not the division, that pooling is not allowed. And in fact, the division even gave an indication that pooling would totally be allowed. So you have to check with your association lawyer on this, but most of us seem to agree that if you're going to start pooling your structural integrity reserves right out of the gate, probably don't need a vote of the owners, but if you're going to straight line them and then go next year pool it, then you probably will need a vote of the owners. And you can talk about that with your association's lawyer. Hope you enjoyed that really quick list. Now, they only gave me 10 minutes. Forgive me if I make it almost 12 minutes. I've timed myself a couple times on this. We'll see how close I get. I'm going to start the clock, and here we go. Start. Milestones. There were exceptions, right? they didn't apply to the single family, 2-family, 3-family dwellings with 3 or fewer habitable stories. Well, now that also includes 4-family dwellings as well. So 1, 2, 3, and 4, not higher than 3 stories, can be exempted from that requirement. We have new definitions. We no longer have requirements for the condominium board to create hurricane shutter specifications. As you'll be hearing, you will now be setting specifications for hurricane protection. That means every single condominium association board needs to get with their lawyer, because you now need to change your hurricane shutter specifications to hurricane protection. We now have kickbacks in 718-103. We have new definitions of condominium property. Why? So that we can clearly legislatively have condominiums inside of buildings. And there's a way paved for that now as well. Electronic voting, 718-128 for you statutory buffs. If the association opted into electronic voting and then the member opted in, association, you don't have the choice but to provide electronic voting unless the member opts out. So once you create the electronic voting platform, you must offer the electronic voting. You can't say, yeah, we're not doing it this year. Kickbacks. We're now jumping into changes to 718-111. An officer or director who knowingly offers to accept or accepts a kickback, just offers the kickback, right? Offers to accept one, commits a felony of a 3rd degree. We're going to talk about misdemeanors of the 1st degree, and we're going to talk about felonies of the 3rd degree. Felonies of the 3rd degree are up to 5 years in prison. Misdemeanors of the 1st degree are up to 1 year in prison. So keep that in mind. Upon a complaint to the Division of Condominium that the association is not maintaining proper insurance or fidelity bonding, then the Division of Condominium must monitor the association for compliance and can even issue fines and penalties. Clarification is provided that in regard to official records, email addresses and facsimile numbers are only accessible to unit owners if the owner consented to receive their official notices by electronic transmission or personally provided their written approval that you can share that information. So unless they've opted in, if someone is making a membership request with all the membership records, the email addresses and fax numbers are not to be provided unless the owner said okay to it or opted in, one way or the other. Official records now include all invoices, transaction receipts, deposit slips that substantiate any receipt or expenditure of funds by the association, a copy of the building permits, copy of satisfactory completed board member educational certificates. You're going to hear about quite a change to the certification program in just a few moments. Official records. This is really interesting in the legislation. Official records must be maintained in an organized manner that facilitates the inspection of the records by the owner. No more just dumping them and saying, here, go find what you want. They have to be organized in a particular manner to make that inspection, to facilitate the inspection, if you will. On the bright side, if we have everything posted on the website and an owner makes a request, we can now lawfully direct that owner to the website. That is a tremendous boon. So glad that is in there. With good comes a little bad, so that part's good. But now when the owner makes a request, you actually have to provide them a checklist of all the records you are making available for inspection and copying. So that's an affirmative obligation on the association, technically on the association manager, where that duty will probably lie. So they are creating more of a transparency in the record inspection process. A director or member of the board or manager who knowingly and willfully fails to provide records, official records, and you've done that twice within a 12-month period, you knowingly and willfully fail to do it, that's going to be a misdemeanor of the 1st degree. It is punishable as a misdemeanor. If a person willfully and knowingly refuses to release records with the intent to avoid or escape detection, arrest, trial, or punishment, then it's a felony of the 3rd degree. So bear that in mind. I don't think that's going to happen to anybody that's listening on today's presentation. At least I hope not. Now, a residential condominium. We're switching gears to 718-112. A residential condominium association with more than 10 units, that's just about all of them, must meet at least once a quarter, 4 times a year, where the meeting agenda includes an opportunity for members to ask questions of the board. This is not an additional meeting. You can incorporate this into your regular board meetings. The Right to speak at meetings with respect to designated agenda items also includes the right of the members to ask questions relating to reports on the status of construction or repair projects, status of revenues and expenditures during the current fiscal year, and other issues affecting the condominium. Oddly, the legislation does not include an obligation of the association board to answer, but you're there to help the members. You're there as their agent. So I would think you would want to share that communication. It's very sad that the legislature had to go out of its way to provide this opportunity. If you're a board and you're trying to do things in the dark and not include your membership, you got to ask yourself why. Your best resources are your membership. If condominium association board meeting agenda item relates to the approval of a contract for goods or services, well, then a copy of that contract has to be provided with the meeting notice. So you got to watch for that. That's new. Board member certification requirements. In the past, there was an or. You could do the lying approach. I read the governing documents. I will abide by them, and I will faithfully discharge your duties. I use lying approach as a humor. All right? I don't mean it seriously. I would certainly hope everyone who signs that piece of paper actually read them. But now, not only do you have to take the course, the board certification course, which is now minimum 4 hours as per this legislation, but you also have to sign that 8.5 by 11 piece of paper that you read the governing documents, you will abide by them and faithfully discharge your duties. And by the way, everybody on this webinar has homework. When is the last time you actually read your governing documents? You're not going to understand everything in it. It's a wonderful tool to help you sleep at night when you have insomnia. Read a few paragraphs, you will go to sleep, but you need to read the whole thing cover to cover at least once. Once a year is probably a very good idea. The board certification is good for 7 years. So if you're going to serve for 8 years, you're going to have to recertify in that 8th year, according to this legislation. And you will have continuing education requirements of I think it's 1 hour per year for the condo. You're going to hear about a completely different regime for condo certification for the HOA board members, just to give you something to look forward to. If a director, officer, right? You're guilty until proven innocent. If you forged an election ballot, theft, embezzlement, destruction, or refusal to allow copying of official records, just the accusation of it, and law enforcement gets involved and you get charged with a crime, why those charges are pending, you cannot be on the board. You cannot run for the board unless you get a court order as well. We now have a whole big laundry list of things considered election tampering, for which it's punishable as a misdemeanor of a 1st degree. Not going to go through the entire list, just the high points. Preventing a member from voting as they intended, menacing, threatening, using bribery, giving or promising, directly or indirectly, anything of value in exchange for a vote. Threatening a member by force, indirectly, violence, intimidation, tactic, coercion, agreeing, conspiring, combining, even the word confederating with at least one other person to commit a fraudulent voting activity. All of that will lead to misdemeanor charges. Hurricane protection. We're totally changing gears now. 718-113. No longer do we have hurricane shutters. Great job on this one, guys. Really a great job. Hurricane protection. Each board of the residential condominium or mixed-use condo must adopt hurricane protection specifications for each building. The board, with the approval of the majority of the voting interest of the condominium, can require or install, the board can do it, or they can require the owners install hurricane protection that complies with or exceeds the applicable building code. A vote of the owners will not be required if the installation, maintenance, repair, replacement of hurricane protection is the responsibility of the association pursuant to the declaration. So that's similar to what we have now with hurricane shutters. Substitute in the word hurricane protection, and that will cover about 75% of what you need to know. If the owner is obligated to install hurricane shutters, has to remove them, and doesn't, the association has to step in, those charges can actually be treated as an assessment. What the legislature doesn't tell you is there's a process to convert monies due into an individual assessment like that. And there's case law out there. So you're going to have to get with your lawyer. Don't just throw those charges on the ledger and expect the lawyer to be able to go into court. There is a process to do that, but you're going to have to chat with the association lawyer to get the detail on it. If we had 3 or 4 hours today, we could go through it, but we don't. Statute of repose. How am I doing on time, guys? How am I doing? Statute of repose. The last date and time by which you can bring a cause of action. Let's say your condominium is built and there's a 7-year statute of repose. That means 7 years from the date of the CO or temporary CO, you can't bring your claim even if it's within the 4-year statute of limitation. Wow, what does that do? Completely wipes out defect claims. What about the condo that turned over in year 7? How are they ever going to have time to have an engineer do a once-over of the building within timely to file a lawsuit if they need to? They wouldn't. So this got fixed. The statute of repose begins to run from the date of turnover of the condominium association. That's a huge consumer protection boon. So now if something happens in year, as long as you're not greater than 7 years from the date of turnover, that's why you want to mark that date carefully, you will be able to still bring a construction defect claim. So it's nice that that got fixed this year. SLAP suits, that's a big one. In the up until this legislative session, if a unit owner filed some kind of complaint against government association, the complaint was about the association to local government, and the association took retaliatory action against the owner, that's a SLAP suit. Well, that's now expanded if the owner files complaints against the association in one fashion or another, not just to local government. Maybe they file a lawsuit because they're upset with something at the association. The association is now prohibited from taking certain retaliatory action similar to the SLAP suit that they cannot bring. Examples of conduct for which a condominium association officer, director, or agent may not retaliate include, but are not limited to, the unit owner complained in good faith to government agency. Unit owner organizes and participates in a unit owner organization. Unit owner submitted information or filed a complaint alleging criminal allegations. Unit owners simply exercise their rights under Chapter 718. You cannot take retaliatory action. If the unit owner complained to the association, you cannot take retaliatory action. The unit owner made public statements critical of the operation or management. You cannot take retaliatory action. Evidence of retaliatory conduct can be raised by the owner as a defense in any action brought against them, and the court is now obligated to expeditiously handle that particular complaint. In addition, condominium association cannot expend association funds in support of a defamation, libel, slander, tortious interference claim against an owner or other claim based on any of the aforementioned conduct. Division of jurisdiction has increased jurisdiction, if you will, over many matters, procedural aspects, record requests, which they have, assessments, fines, commingling of reserves, operating funds, use of debit cards, annual budget complaints, allocation of reserve funds, financial records and other records to determine revenue and expenses, certainly elections, maintenance of and unit owner access to association records, procedural aspects of meetings, disclosure of conflict of interest requirements, removal of directors and officers, procedural completion of the structural integrity reserve study, certified written inquiries by owners in regard to certain items as well. In addition, the ombudsman is welcome at any meeting of the association, as are the ombudsman's representatives. So you cannot say to the ombudsman representative, you're not a member here, you can't be in the room. Florida statute says, yes, they can. Finally, we're going to wrap up. There's, interestingly, because in two of the bills, the condominium bill and the homeowner association bill, you're going to hear about new CAM requirements for the licensed community association manager. They must return all of the records to you. When you say, okay, we're done, we're moving on to a new company, the management company is now obligated to return the records to the association within 20 days. Failure to do so creates works like a rebuttable presumption. They willfully failed, and there are fines that can be assessed against the management company for doing so. Any type, I'm going to fast forward because we are limited in time, but I have 2 pages of descriptions of activities that are not permitted that give rise to that conflict of interest. So in plain English, if you as a board member, your family member, or anybody within what they call the 3rd degree of consanguinity stands to earn a penny from any contract with the association, including the management company, if you stand to receive a benefit because of a family member doing business with the association and you're on the board, you have a conflict of interest. What to do about it? Minimum disclosure. There may be other things you have to do as well. You will have to get with the association's lawyer. If we had an hour or two to talk about this particular bill, we could go into detail, and I'm sure we will all be doing those webinars, so stay tuned for those. But there you go. Let's talk in detail. Let's get into the nitty-gritty on this bill.
So Jeff, if you'd like, there's a comfortable leather chair behind you in your virtual background. If you want to take a breath and relax for a second, catch your breath. That was a great thumbnail presentation of a massive piece of legislation. Elizabeth, Bryony, comments?
Well, I would just say, Tony, the thing that strikes me as particularly beneficial is the requirement for board meetings. I have attended election meetings for clients where members stand up and say, you never have meetings, you never have meetings. And sometimes the board gets very consumed with the day-to-day operations and just operates in their own little bubble and doesn't have any interaction with the membership. So this provisions now require at least 4 meetings a year. And as Jeff pointed out, the opportunity to ask questions of the board. So, that's certainly a step in the right direction for transparency.
It's such a shame they had to legislate that, right? It's common sense. You're on the board. You should be having the board meetings. You shouldn't be doing business in the dark.
Well, but shouldn't you also have the obligation to answer those questions? I mean, I appreciate your point that you owe a fiduciary duty to the community to act in its best interest, and responding to those questions is likely contained therein. But if we have to legislate that folks have the right to ask questions, then don't we also need to legislate that someone should be answering those questions?
That they should answer to the best of their ability. Maybe that's something for Tony and Travis to put into next year's legislation. And hopefully we have just a little bit of legislation next year compared to this year. 6 inches of legislation, everybody. Just a huge book binder.
The other thing, sorry.
Oh, sorry. Go ahead, Elizabeth.
I was just going to say the other thing that is helpful about communication with the members and live communication is many times members operate on the periphery and don't pay attention. There may be newsletters, there may be web posts, there may be email blasts, but if they're not reading them, they really don't know what's going on. So that in turn can breed rumor mills that can be addressed by these in-person meetings. So or meetings where members have the right to ask questions.
Yeah, and I think the overall, and for the HOA bill, I think if we had to, transparency would be certainly one of the words if we were putting together a word cloud that they really want, whether it be the meetings, the website, lowering the threshold so that more people have access to the website, those kinds of things. This is one of these pieces of legislation that came directly out of legislators going to these town hall meetings and listening. And they were going to the town hall meetings to try to explain some of the changes from, the structural issues, changes, and then heard a whole host of things and started to realize, wait, we better get the foundation correct. And I remember being in a meeting in I think it was Key Biscayne over the summer, one of these town hall meetings, and people were saying, we go to these meetings, we're not allowed to talk, we're not allowed to say anything, we just listen and are told things. And then the other half of the room said, oh my God, how lucky are you? You get to have meetings? We don't even have meetings. So, then, and those issues were being written down so that now we have, you're going to have meetings, these at least 4 meetings. And then it was one draft, it was just 4 meetings. And a thought came, well, does that mean they could just have, okay, we're doing our meeting weekend, Thursday, Friday, Saturday, Sunday. We've done our 4 meetings for the year. And no, it was, we got to spread these out. And then it was, you got to be able to take questions. And then the other thing that I would mention, I think that's a big change, kind of a foundational change, is the expansion of the jurisdiction for DBPR. DBPR pre-turnover could do a lot more. They were much more involved, but then post-turnover, which is where we find ourselves most of the time, post-turnover, they were very limited to what they could do. And so they would get all these complaints and they would look, and if it wasn't one of the magic 3 things or now 4 with SIRS, they would say, oh, not in our jurisdiction, we dealt with, and so they would say to the legislators, I was in these meetings where they would say, well, we've closed 97% of our, and then they only had like 25 investigators to do at a call center over the entire platform of things that DBPR covers, from barbershops to, managers, anybody in the state that had a license other than the medical profession that's under ACA. But all the other licenses, they had 25 people. So part of this expansion of the jurisdiction, which I think is significant, and then them being able to turn things over to law enforcement, et cetera, is almost, over $7 million, almost $7.5 million that has been put to hire 65 full-time people to
That's
help with it.
investigators for the DBPR, but what about for the division of
65 people
condominium?
just for this division.
All right. Well, last I heard, there's a condominium door tax, give or take $4 a year per condominium door goes to the division. Instead of going to the division, though, it goes into the general coffers of the state of Florida. And then, as I hear it, about 90% of that money gets used on everything but condominium DBPR.
Yes. They have swept that repeatedly over the years.
Right. How do they expect to handle all these complaints without sufficient funding for the division of condo?
Well, one of the things that we'd always been talking about is the fact that these people that pay $4 a door, whether for education, for a robust DBPR regulatory body, millions of dollars were getting swept into, as you said, general revenue, which means it can then be used for schools and prisons and other worthwhile things. But when I would bring that up, or we'd bring that up, they would say, well, people in condos, they drive on the roads, and people in condos go to schools. And I said, yes, but they're also paying gas tax and property tax for all those other things like everybody. This is special that they're paying over and above. So one of the ways to stop it was they had to encumber the money so that therefore it's not, when the budget's being put together, it's not extra. So the dollars that are being used for the hiring of these people are coming in large part from the amounts, the surplus, the over $2.5 million a year that was always being swept. So now that money won't be able to be swept because it won't be extra.
And what about homeowner associations? Is there any talk about a door tax that will go to the division now that the division has jurisdiction?
Yeah, there has not been for many years because exactly the way you phrase that, it would be deemed a tax, and somebody would run, a mail piece against, Jeff Rimbaum running for the state house.
I'm not running, folks.
Right. They would take the $4 times the number of HOA doors in your district, and they would say, Jeff voted for, $18.7 million of neighborhood taxes. And people would be like, oh, that's, no. So I don't see that I don't see that happening in the HOA side. I mean, things can happen, but I don't see that happening. So there were a number of questions that I was trying to answer rapid fire as they were coming in. I didn't get to all of them. We'll get back to those in a second, and certainly towards the end. But any other discussion, panel on it? One thing I did want to mention that I think will be helpful. Jeff mentioned this at the outset, the website, www.flsenate.gov. Also, if you go there, there's some tabs across the top. One says committees. If you click on that, there'll be a couple of choices, and one will say committee publications. If you click on that, you'll see a list of choices, and one of them is the 2024 legislative summaries. If you click on that, it is every bill, and you'll be able to follow through. And this originated in the Committee of Regulated Industries. So if you go into the Regulated Industries Committee, you'll be able to see not only this bill 1021, but the other bills that we talk about, and you will get a really good, I think the Senate does a better job, honestly, than the House summaries, but you'll get a 6-page summary of this bill that you can certainly share with your board and members and educate yourself on.
Travis, one important point I think for people to understand is the legislative environment surrounding community associations. You mentioned the town halls around the state, and the people that largely go to those town halls are not people that are there to say, you know, everything's great in my condo or HOA, and the board is doing a great job. I mean, there are people there that have gripes, in many cases, very legitimate gripes. And generally speaking, the legislature doesn't look very favorably upon condo and HOAs and condo board members and management companies because of the complaints that they hear and because of the sensational stories that come out, like the hammocks in South Dade, where there were abuses by directors. So it's a very difficult environment. As a result, you know, a lot of us think a lot of this legislation may be unnecessary. It's only a couple bad actors out there that prompt this, but it's the reality of the environment that we're dealing with there.
Right. And if you see a story in the Miami Herald that says, you know, we're writing this story because such and such condo association is just a real beacon of community in our area, I would love to see that, because that's just not the stories that get written. And no offense to the media or anybody else. It's just, that's, like you said, nobody's going to a town hall meeting to say, I just want to say I love my board and everything they're doing, my manager, blah, blah. So a lot of times, all the time, what they're hearing are these, you know, horror stories, and often cases, you know, bad. I mean, we have over 50,000 associations in the state of Florida. The vast majority of them, I think, are running very, very, very well. But yes, a lot of the things that we see, and when we get into some of these other bills, like the HOA bill, dealing with, you know, whether it be you know, parking, or whether it be, you know, vegetable garden, whatever the issue is, it's because somebody said, I tried to do this in my association, and you know, to a legislator or a policymaker, and my board, my community, you know, is horrible and shut me down. And so then, you know, rather than getting the whole story, maybe it's easy, you know, we're just going to fix that, you know, so yeah, you're right. You know, certainly as you're building relationships with your policymakers, and you should know who your state representative is, who your state senator is, you need to let them know also, you know, the good that's happening, and to say, I'm available as a resource, certainly, as you're looking at these things.
Yeah, if you read the legislation, you're led to believe, oh my God, every association board out there has some sort of evil component to it, when in fact, I don't know about y'all, but it seems to me like 95% of the boards I deal with, maybe 98%, are trying to do the right thing all the time. It's really the exception to the rule that so much of this legislation is created for.
Exactly.
Right.
Well, let's jump to something that might be a little easier, a little less controversial, Travis. That was the My Safe Florida Home program, the changes that were made.
Yes. So I'll blast through this real quickly. For many, many years, we've had the My Safe Florida Home program that provides, it's under a state agency where an inspector will come to your home. They'll say, you've got these various hardening components that you've done, certain types of roof, windows, doors, et cetera. And we now give you a grant to help cover those costs, and reimburse you, et cetera. We had been trying for a number of years to try to get condos as a part of that, saying, you know, a home's a home, and many folks now, these are not just vacation, second homes, investment properties. These are homesteaded properties. These are homes as well. And so we passed legislation, got passed this year by the legislature, House Bill 1029, when you go to look for the summary, et cetera. And it's a pilot program. So it's something that is only going to be on the books for a few years, and then it would, if we don't change it or reauthorize it, the legislature, it would go away, what we call sunset. And then starting July 1 in the new budget, when this program, if this bill gets approved, which I think it will, the amount that we put in is only $30 million. Sounds like a huge number, obviously, to us, but when you look at all of the associations that could benefit from this, but it is important to get, you know, you can get an inspector. The association does not have to pay for that. The state reimburses that inspector. They will come out, or pays for the inspector. They will do the inspection. You then go through an application process, the board. So let me run through a couple of quick bullets. And then, again, this would take effect in July, but I think it's something that not only would you be able to get money back from the expenditures that you've done for your association, hardening it, but also then you could get wind mitigation credits and other things for your insurance, which obviously is a huge deal. The program covers condominiums that are located within 15 miles of a coastline. So that's something to keep in mind when you're looking at whether or not to apply for this. The maximum grant amount, the whole grant amount that an association could get, again, out of that $30 million pot, is $175,000. And the way that's kind of broken up is $1,000 per unit for the roof, and then $1,500 per unit for everything else. This also is a program that is not something that an individual does not apply to the unit owner. Obviously, you can still, when you're dealing with your HO6 unit owner policy, can still provide information saying, I live in a building that's got this, and this as far as hardening attributes. But the program, again, this is the pilot program for this is for the association. In order to participate, you have to get a majority of the approval by a majority vote of the board of administration and the total voting interest. You actually have to get, there's some steps, but you have to get, again, pilot program. I want to try to change this, or we want to try to change this, but right now, because it's for the whole building, the whole envelope, so this is about physics, you have to get 100% have to agree that, hey, we want to go forward and apply for this. The associations must provide a detailed application, including information on the contractors that they use, the commitments to complete any mitigation improvements, and then the application has to be signed by the board and notarized. So I will leave it there for now. I think this is a good thing. I think I encourage you all, when this goes into effect, I think everybody should apply, get an inspection. It does not, there's no delineation on the size of the building. It could be any building. Again, it's just if you're within 15 miles of a coastline. Because I want to be able to show, hey, that $30 million went very quickly, so that next year we could try to get the regular My Safe Florida Home program for single family homes is up to like $280 million. So this would allow for, I want to be able to try to get more than 30, but that's where we are for this year. Does anybody on the panel or anybody have any questions, anything on that? Okay, Tony,
Travis, we're ready to jump into 1203, I think.
Yes. So as I mentioned at the outset, we had a big condo reform bill. We also had a big HOA reform bill. And as Tony mentioned, a lot of this is coming from, the horror stories that were out there with people just stealing essentially millions of dollars. So, Bryony, why don't you, if you can, kind of also step us through 1203 and then we'll have a discussion on that.
Absolutely. So I was very impressed with Jeff's fast and furious presentation. I hope everyone's stretched their fingers out if they're taking notes. I'm going to see if I can do that too. All right. House Bill 1203 begins by adding a paragraph to Florida Statute 468.4334. That's the CAM Professional Standards Statute, which would require managers who manage HOAs to attend at least one membership or board meeting each year. It would also require the manager to provide the members with the name and contact information for each representative of a management firm assigned to an HOA. They would also have to provide each representative's hours of availability and a summary of their duties. And this information must also be posted on the HOA's website and updated within 14 days from any change. That section would also require a management company to provide any member with a copy of the contract between the manager or management company and the HOA upon request. Next, House Bill 1203 will amend Florida Statute 468.4337. That's the CAM Continuing Education Statute. It provides that not more than 10 hours may be required for renewal of a CAM license and 5 hours of continuing education biannually, pertaining specifically to HOAs with at least 3 hours on record keeping. Next, House Bill 1203 will amend Florida Statute 720.303. First, it adds a specific reference to the fiduciary duty section of the Not-for-Profit Corporation Act. And then it adds website requirements to the Homeowners Association Act, such that every HOA with 100 or more parcels must have a website by the 1st of January 2025. Next, House Bill 1203 would require each HOA with 100 or more parcels to post specific listed documents on their website or through a mobile application. And a lot of those documents are going to be familiar. They're very similar to a list that I believe Jeff gave you a moment ago. Recorded articles and amendments, recorded bylaws and amendments, recorded declaration and amendments, the current rules, a current list of executory contracts or documents to which the association is a party, the annual budget and any proposed budget, the financial report and any monthly income or expense statements, current insurance policies, education certificates for each director, any contract or transaction between the association and a director in which the director has a financial interest, any contract or document regarding any conflict or potential conflict of interest, notice of any scheduled meeting of the members and the agenda for the meeting, notice of any board meeting with agenda, and new provisions include parameters for the website, including a password protected section for owner access only, and parameters for redacting protected information from records. The association must adopt written rules governing the method or policy, governing records retention, and the time period such records must be retained. If an HOA intends to use their website to satisfy the new requirements of House Bill 59 to provide all owners with copies of the association covenants and rules, that website will need to be operational before the House Bill 59 deadline. That's October 1st of 2024. Next, House Bill 1203 addresses crimes, starting with records access crimes. These are very similar to the ones added to the Condominium Act in 1021, except for there's some intent parameters added in the HOA law that is not present in the final product of the condominium bill. So a board member or CAM who knowingly and willfully repeatedly fails to retain or provide access to association records with the intent to cause harm to the association or its members commits a second-degree misdemeanor. And again, same as with condo law, repeatedly means 2 or more times in a 12-month period. Anyone who knowingly and intentionally defaces or destroys an accounting record, or who knowingly or intentionally fails to prepare a record with the intent to cause harm to the association or one of its members commits a first-degree misdemeanor. Any person who knowingly and intentionally refuses to release or otherwise produce association records with the intention to avoid detection for commission of a crime or to assist another person with such avoidance or escape commits a felony in the 3rd degree. An association must respond to any law enforcement subpoena within 5 days or as directed by the subpoena, and the association must assist the law enforcement agency in its investigation to the extent permissible by law. And that comes directly from the Hammocks. One of the Hammocks prosecutors spoke at a panel in Tallahassee and explained that he had great difficulty getting the association to respond to subpoenas. An association with 1,000 or more parcels must prepare an audited financial statement, notwithstanding the association's total revenue, and an association can no longer prepare a lesser financial statement 2 years in a row. Debit cards may not be used, and any debit card used for a reason that is not approved in the minutes or included in the budget is theft. Accepting kickbacks becomes a 3rd-degree felony. A director is removed from office and a vacancy declared if the director is charged, not convicted, charged with any crime set forth in Chapter 720, as well as forgery of a ballot envelope or a voting certificate, embezzlement or theft of association funds, or destruction of or refusal to allow access to association records in furtherance of a crime. Next, House Bill 1203 adds a new owner right to request an accounting. A parcel owner may make a written request for an accounting from the association, and the board must provide such information within 15 business days from receipt of the request. Failure to timely respond constitutes a waiver of any fines that are more than 30 days past due. An owner can only request an accounting once every 90 days. Next, House Bill 1203 focuses a lot on board member education. A newly elected director must complete a new director education curriculum within 90 days from being elected. The curriculum completion certificate is good for 4 years, not the 7 years that the condominium certificate is good for. The new director curriculum must include financial literacy and transparency, record keeping, the levy of fines, notice, and meeting requirements. Additionally, directors must complete at least 4 hours of continuing education annually, unless their association has 2,500 parcels or more. Directors in these larger associations must complete 8 hours of education annually. DBPR is also instructed to adopt rules for implementing these new education requirements. Next, House Bill 1203 addresses architectural review, and this is important. Architectural standards cannot limit or place requirements on interior changes that are not visible from the frontage or an adjacent area. That will be interesting to see how that plays out in townhomes, where load-bearing walls are interior and they certainly impact the home of your neighbor. So it will be interesting to see how that plays out. Next, architectural standards cannot require a review of plans and specifications for air conditioning systems or the like that are not visible from an adjacent area and are substantially similar to systems that have been approved by the association previously. Let me reiterate, they cannot require review of the plans and specifications. Can't even look at it. If the association denies a parcel owner's request or application for construction of a structure or other improvement on a parcel, they must provide written notice to the parcel owner stating with specificity the rule or covenant the committee relied on when denying the request and the specific aspect of the proposal that did not conform to the rule or covenant. So I would expect that our HOA friends on this presentation are considering the revisions that they'll need to be making to their architectural standards. That's a step that I would start looking at now, even though the bill has not yet been approved by the governor. Next, House Bill 1203 limits the storage statute, that's 720-3045, by expanding the list of areas from which storage cannot be visible. House Bill 1203 adds to the fine process in HOAs. First, an HOA sends an owner a notice of a violation and a right to a hearing, as they do now. The hearing must be held within 90 days from the issuance of the notice. That's new. And the committee hearing may be held by telephone or other electronic means. If the violation is cured before the hearing, the fine or suspension may not be imposed. Now, I host Becker's legislative weekly briefings, and so we've gone through each version of these bills as they're considered by the legislature. A previous version of this bill said if the violation is cured the day before the hearing, which makes sense. This version that was finalized says if the violation is cured before the hearing. So theoretically, if the person cures the violation on the walk over to the clubhouse to attend the hearing, well, that violation was cured before the hearing. And if on the walk back, they put things back where they wanted them, well, that fine or suspension may not be imposed. Within 7 days after the hearing, the committee must provide notice to the owner and any tenants of the committee's findings. That's new, including any fine or suspension approved or rejected by the committee and how the owner may cure the violation and a date by which the fine must be paid. The committee must set a due date for the delivery, and that due date must be at least 30 days after delivery of the written notice required to be sent within 7 days after the hearing. If that sounds confusing to you, well, it is. The committee must set a due date for the fine. And that due date must be 30 days after the delivery of the notice. So you're setting the due date, but in the letter, but you don't know when the letter is going to be delivered. And then the due date must be 30 days after delivery of that notice. Next, The association attorney's fees and costs may not be awarded against the parcel owner based on actions taken by the board before the date set for the fine to be paid and before a time to appeal has expired. Now, previous versions of this bill had an appeal process, which was taken out during the amendment process, but here there's still reference to a time for appeal. The association may not fine or suspend for leaving garbage cans out of the curb for 24 hours before or 24 hours after garbage day. Additionally, leaving holiday decorations or lights up less than 1 week after the association provides written notice to take them down. A previous version of this bill said that you could, or that you couldn't fine if the holiday lights were left up for a week after the deadline to take them down. Now you're obligated to send that written notice. Those holiday lights can stay up till June if your and beyond if your association doesn't realize that it needs to send a written notice requiring them to be taken down. Next, House Bill 1203 addresses fraudulent voting crimes, adding to the list of voting crimes that were adopted last year. The new crimes are conspiracy type crimes, and they're all first-degree misdemeanors. Knowingly aiding, abetting, or advising a person in the commission of a fraudulent voting activity related to association elections is one. The next one is agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent voting activity related to association elections. And the third is having knowledge of a fraudulent voting activity related to the association elections and giving aid to the offender with the intent that the offender avoid or escape detection, arrest, trial, or punishment. Additionally, House Bill 1203 adds to Florida Statute 720-3075, prohibited clauses in association documents. It would prohibit an association document from prohibiting vehicle parking in the driveway. So pickup truck parking in the driveway. A pickup truck may be parked anywhere a person has the right to park under state, county, and municipal regulations. And regulating pickup truck parking is now up to your county municipality. Most municipalities near me, I'm in the Bradenton, Sarasota area, they haven't addressed it. I'm not sure here whether it's been addressed by municipalities, but on the West Coast in my area, it has not been addressed by municipalities. And let's see, House Bill 1203 would also prohibit an association from requiring folks to use its preferred vendors and from restricting property access solely because a contractor or worker doesn't have a license. And finally, House Bill 1203 allows one to consent to electronic voting electronically, and it allows first responders to park their vehicles in an area where the owner otherwise has the right to park, including public roads or rights of way.
So, Bryony, one of our attendees raises an interesting question, and I think related to everything we've discussed so far today. They find it difficult. They live in a 2,500 unit community HOA, and they can't get people to run for the board. They can't. Is this legislation now with criminal penalties, mandatory education requirements? What's the impact going to be on communities and trying to find people who are willing to volunteer their time to serve on boards?
Well, I agree that the education requirements are significant, and I think it is going to impact the people's interest in running for the board. I think that certain professionals, we have professionals who volunteer their time after work and on weekends for the good of their community. And are those folks going to be willing to take on the additional burden, the additional obligation, and the additional liability? But when raising that issue with legislators, I was told that they hear from folks across the state who are interested in running for their boards, that there are no shortage of interested people and that they'll see how this plays out.
I'd like to chime in on that as well, because in the condo legislation, we have a 1 hour continuing education requirement. In HOA, less than 2,500 parcels, 4 hours, more than 2,500, 8 hours of continuing education. God forbid there ever be any parity between Chapter 718 and Chapter 720. Why can't the legislature, when they're doing it for one, Tony and Travis, do it for the other when it on stuff like this? But 4 hours and 8 hours is going to have to be corrected, I think, in a future legislative session. It's just too onerous. It's the right idea. I love continuing education. I think they started to get it right with the Condo Act, 1 hour of time, and I could see it maybe going to 2 hours. But you go beyond 2 hours, all of a sudden, I think we're going to lose good candidates because of this. That's my 2 cents.
Yep.
Yeah, I go back to what Bryony said though. I mean, I've been in these meetings where I'm hearing scores of people say, we try to run for the board. They play games with the election, with the eligibility for election. Somebody will say they'll resign, and if there's only one person on the ballot that they don't now like, they'll have the person that resigned, that board member, get back on so that they can keep that person from winning and all this stuff. So they're hearing, I can't get on the board. So until the pendulum swings the other way and they actually hear, we don't have enough, we really honestly do have no people that can serve. It's not just something we've been saying that without reality. Then until that happens, we'll continue down this road.
I say this somewhat jokingly, but somewhat seriously as well. It's almost as if we need a personality test, right? A new criteria to live in a condo or an HOA. A personality test that you're going to be homogenous with the people that live there, fine. But more importantly and seriously, that you understand there's a declaration of covenants, that there are rules. It's as if these people are moving into the community associations and they want no encumbrance. They want none of the benefits of living in the community association. They don't want to have to abide by the covenants. Who are you to tell me I can't have a volleyball net in the front yard comes to mind. It's just absolutely ridiculous. So I think the legislature also is hearing from a vocal minority that to a great extent, what was it? The hammocks, right? We have the largest
Right.
HOA in the state of Florida. We have over $2 million, maybe $3 million embezzled. And a lot of the HOA legislation came from this. It's the one off. It happened once. It's not like it's happening every day, everywhere, but yet we're legislating for that one-time occurrence. And we should be legislating for the 99.9% of the good people out there. It'd be nice to get that message to the legislators. But I mean, I
Absolutely.
commend them for a lot of the good work they did as well.
All right, panelists, let's go into acceleration mode here and try to get through what we've got to get through. Jeff, Senate Bill 1198 was a quirky little thing that was thrown out there. You want to give us a comment on that?
Corporate actions, sure. You almost threw me there with the bill number. There is a new set of procedures, right? We all know that sometimes we make a mistake. I'm on the board. You think I'd know better, but I'm on the board for over a decade of my HOA. And even on our board, sometimes a mistake happens. A decision is made outside of a properly noticed meeting. Well, how do you fix it? You need to put on the agenda ratification of prior action. And then at the board meeting, you do a full disclosure of what happened and you ratify that act. And that pretty much cleans it up. Well, now there are procedures to follow within Chapter 617 for that ratification process. You can read about them or hear about them on a future webinar. I'm not going into that level of detail today, but to just know that there is a new process for ratification.
Good. Travis?
Yes.
Vacation rentals.
Yes, real quick, vacation rentals. This is a bill that's been around for about 8 years. And finally this year passed. Of all the bills that we're talking about, this would be the one that I think the governor's taking the closest look at as far as a potential of a veto. Nothing obviously official on that, hasn't received it yet, but that's Senate Bill 280. I think the only thing that we need to keep in mind here is that it does not in any way, even though they're preempting now a lot of the regulation from local governments, cities and counties to the state, it does not preclude an association's documents from dealing with rental restrictions as they see fit in the community, whether you're in 718, 19, or 20. That language is still there expressly providing for that. It's in section 21 of the bill if you look at 280.
All right.
Travis, I think if I could just chime in real quickly, the concept in this bill seems to provide an overarching registration and licensure at the state level, and a registration at the local level. Both
Yes,
would
they
be
can still,
required.
yeah.
Yeah, both would be required and tracked on what is purported to be a omnipresent website that would be available for an advertising platform to check and see if the licenses for the individual short-term vacation rental owner are up to date, and whether the advertisements can be put on the advertising platforms. That looping in of the advertising platforms is a significant step, I think,
Yeah.
and maybe a challenge.
Yes, I mean, there's some thought that, maybe this helps with the policing, and I use that for, of seeing where these are, because right now we don't have a real handle on, there isn't a handle on where these exist. The idea is to try to do that. There was some disagreement between the two chambers as it relates to what kind of information to put out there because they didn't want to have personal information. Now your address, personal, these kinds of things. But yeah, that's something that I think is going to have to be worked through. And again, problem is DBPR, they were only given money for this to manage all of that, 9 people. So here we give them 65 to deal with all the condos and now, mobile homes, timeshares, condos, co-ops. Now they're only going to have 9, you think how many just does the city of Fort Lauderdale have already just dealing with that? I don't think it's going to be enough. I've told the governor's office, it doesn't, if it doesn't, we don't need it. Because again, we've got our protections, I think, in place as it relates to associations. So we're going to have to see what happens with that one. But it's one of those that we mention it because it did pass after all these years of not passing.
Yeah, and I think a lot of our clients complain about the short-term vacation rentals because they can't enforce against them. And there was some provision in here for code violations leading to the revocation of the license, for suspension of the license, opportunity to operate the short-term rental, which I think would be, welcomed by some of our associations who really are having a difficult time trying to police them from within the associations, even though they are prohibited under the governing documents.
Right, right. And that, yeah, there's some, one county in particular has a good registration system to allow for that. They were exempted out, which I think might be the reason really why this might get led to a veto, just simply because if it, we should be allowing it for associations in any county should be able to utilize that.
Mm-hmm.
And if their local governments are doing a good job for that, that helps the association.
Travis,
Anything else from the panel members on that?
No,
Okay.
but I'll add to the fact just one thing, that sometimes it's really surprising when the governor gets the bills and he actually does veto one we didn't expect. It's happened in years past. I don't know if it's going to happen this year, but somehow somebody gets his ear, whispers something to him, and the next thing you know, one of the bills is not signed. So remember, everybody, none of these bills have been signed by the governor yet. None of them have made their way to his desk. And Travis, there's no requirement from the time the bill is enrolled. It's passed the House, it's passed the Senate. The technical word is now we have an enrolled bill, and that's the bill that goes to the governor's desk. And there's no time requirement. We have that 15 days from the time the governor gets it, right? And then it either passes into law if he does nothing in 15 days, where he can sign it right away, or veto it. But what about the only time from enrollment?
No, yeah, the only time that operates there is the effective date. So in other words, they would have to give it to him, the ones that are going to affect July 1, and then there's October 1 and January 1. They would have to give it to him certainly within 15 days, of the effective date. So they couldn't wait until June 30th, or June, 20th. They have to allow at least for that. But otherwise, no. There's been bills we've been waiting and waiting and waiting, and it's, well into April or May before they get sent. And they also tried to do the governor's staff a favor by not sending them, 355 bills and the budget all at one time. They try to do them because then the clock is starting on everything. So they try to kind of provide them in batches. So,
Travis,
yeah, do we have anything
let's-
else on that? I know we're trying to.
Yeah, let's jump to HB 1503 with citizens.
Yeah, real quick.
Mention
Yeah,
of
it's
that.
the citizens bill that passed. It was very, very, very disappointing that more was not done regarding insurance. Insurance is the biggest issue that associations, Floridians really, I think, are probably facing, but certainly associations. The only thing that I think that happened in this bill that is of note is that for community associations, for condos, surplus lines companies can now take them out of citizens if they are homesteaded. I'm sorry, if they are non-homesteaded properties. So for second homes, vacation homes, those kinds of things, they could go into surplus lines. That's kind of a mixed bag because they're not those companies, while they're big, good companies, I think your claims get paid. They're not regulated by the state at all. So those forms, what they cover, the rates don't have to be approved. They can just be raised. So that, I don't know where that helps other than Citizens right now is the only admitted player really in our space. I think there's going to be a special session on insurance because I think especially when they're looking at these poll numbers going into a November election and realizing that they have not done the number one issue, any real service, I think that they will have to have a special session. We tried, whether it be on getting, citizens to take more of the wind, whether it be citizens take wind where there's rentals in a building, dealing with all kinds of things that again, there was no appetite to do. But that change did happen regarding surplus lines.
Okay, Estoppels, certainly a large topic of conversation this session.
Yes. So there was a bill. This was an issue that we had dealt with 6-7 years ago, had worked a really good compromise. The system was working well. Estoppels were being done and being done accurately and timely. Closings were certainly happening. There was a move that generated really out of the Senate to completely change that process. 280 is a bill that was filed. I'm sorry, that was vacation rental. 278, a bill that was originally filed that would have just gotten rid of the ability for an association or their authorized agent to charge for any of this work, and changed the timetables, changed a whole bunch, just completely really messed with the system. We'll put it kindly. We continued to work this all the way through the process. The House had a different approach, and really wanted to go just after some third-party actors that they believed were behaving, kind of outside of the scope, outside of the fee caps that were statutorily allowed. This bill, a lot of you emailed. I heard from a lot of legislators that they got a lot of emails, phone calls, communication. So that's great. And that bill did not make it, did not pass this year.
Yay.
Okay, is right.
Yeah, it would have been very cumbersome and expensive for associations.
Oh, it was absolutely ridiculous. One version of the bill took away the ability of the association to charge the requesting party for it. Another version gave them a quick 7-day turnaround time. It was just ridiculous. I'm so glad that one did not make it through. Big win.
And it took a lot of work educating legislators because there were so many of them that think that all this is pushing a button and why should there be any charge for it? So it did take a lot of work and a lot of effort and a lot of communication from board members that ultimately, if what the legislature initially was attempting to do, the cost was going to fall on all owners in an association as opposed to the parties to the transaction. So it was an educational effort that took a lot of work by a lot of people to try to get this back to, as Travis mentioned, we negotiated in 2017 and came up with a very good proposal that established caps, that greatly expanded what had to be included in the Estoppel information for the benefit of prospective purchasers. And it's been working. There were a couple of bad actors again, and as a result, we had to fight off, some bad legislation. So, good job on that one. Travis, anything else in the catch-all bin of other legislation?
I mean, there was the only other bill that I'll mention that did not pass that a lot of people had concerns about early on was a House Bill 173 that would have said for HOAs, 15% of your budget would have had to been given to a charity.
I just have to laugh at that, Bill. I'm sorry. It's altruistic.
What?
Yeah. So those again, I'll put a quick bow on this, Tony, but it again goes to your comments that there's just a lot of members that just don't understand how common interest ownership works, and also the value that it adds to somebody's personal, to their property, to their real estate by having certain community standards that everybody agrees to adhere to, but then also just how the budget strains that they're under, et cetera. I don't know of many associations that have 15% of the budget, sitting around in the mattress again, nothing wrong. And we certainly encourage everybody to give to charities, but that just seemed like a mandate that would have been very expensive. But again, a lot happened. We'll continue educating folks with additional webinars and certainly updates through email. I know these law firms and these practitioners who are real experts, they do a great job of getting information out to their clients and others. So there'll be a lot flying around now that session has ended, and we'll keep you up to date when these hit the governor and all of that.
Great. So we've had over 75 questions come in during the course of the presentation. Over half of those we've addressed either directly through live responses or through typed responses that you received. If panelists, if we can just take a look at the questions and answers, and let's buzz through the questions that we have and see how many of them we can tackle. The first one I see here that hasn't been addressed was directed to Elizabeth. Does the DBPR have authority to investigate the performance of a SERS if no unit owner filed a complaint with the DBPR?
Well, the authority of the division is under 718.501, and it specifically provides that if the division has a reasonable cause to believe that a violation of any provision of the chapter or related rule has occurred, the division may institute enforcement proceedings in its own name against any developer association officer, member of the board, administration, its assignees or agents, and that the remedies go through kind of their standard response. One is a consent proceeding where the order would be entered against the association in that instance. And the division may issue an order requiring the party to cease and desist the unlawful practice and take such affirmative action as in the judgment of the division carry out the purpose of the chapter. The division may petition the court for an appointment of a receiver or conservator, which would be very unwelcome. And in addition, subsection R provides that in addition to its enforcement authority, the division may issue a notice to show cause, which must provide for a hearing upon written request in accordance with chapter 120. So I don't know if the division has the inclination to enforce the SERS requirements, but the association is required to now notify the division of the achievement or completion of the structural integrity reserve study. So they will have the information. What they choose to do with it remains to be seen.
Okay. Anyone know why association minutes are not required to be on the association's website?
I thought that normally minutes would be posted in the owner portion of the website for those associations greater than X number of units requiring to have the website.
And it would seem that would be, if not specifically enumerated, it would be in the catch-all at the end, which is anything else that has to do with the operation of the association, right? All of those things are records.
Right. Next one's directed at Briney. Does the provision allowing questions to be asked at 4 board meetings still allow a board to have a rule limiting such questions to only during new business after the board has voted on an agenda item?
Well, the new law doesn't specify where in the agenda the board must take questions. So I would say that yes, the board still has the flexibility to put that question and answer session where they would like, including during new business after the board has voted on items.
And not only that, I think it's okay for the board to pass reasonable rules and regulations saying you can't bring those items up when we're discussing a different agenda item. You have to you get your 3 minutes in the sun about this agenda item. You get that catch-all exception to ask anything you want later in the meeting or early in the meeting, however the board chooses to do that.
Right,
Yes, the board meetings are for conducting board business, and questions off topic during a discussion are not helpful to move the meeting forward. So it makes sense to have those at the end.
And if your association has not adopted reasonable rules governing member conduct, board member conduct at board meetings, at member meetings, then you're really missing the boat. You are behind the times, and get with your lawyer so that they can help you prepare that.
Okay, does building link count as a property's webpage? I don't know. I don't know what building link is. Maybe
I don't know what
somebody
Building
else
Link is. Our association management company has a portion of their website. Go to their website, find our community name, then push the button, then you log in as an owner, and there's all the records that the owners only are entitled to. Meanwhile, there's a section of the website that if you're looking to purchase in the community, well, then you have access to other information that we all have access to. So if Building Link is a program like that and the owners have access to it, why wouldn't it count?
Okay. When can a board convene to have the work portion of decision-making discussion? Performing that concentrated work as part of a meeting requiring member comment usually chokes off progress.
That's why you got to have the member rules, right? The board considers the item.
Exactly.
The board discusses the item without member input. When the board is done discussing the item, if no motion is made prior to going on to the next item, well, then any member can comment. If a motion is made and seconded, board continues to discuss it ad nauseum till they're done. Then the members have a right to talk, right? Every member gets their 3 minutes, back to the board for final conversation and the vote. And if you haven't adopted these rules, get to Byron, get to Elizabeth, get to me, you're missing the boat. I mean, the fact that question is still being asked right now, Tony, is indicative of an association that has not taken advantage of these opportunities that the legislature already provided.
Exactly. Thank you, Jeff. What if a member harasses the board? Is it legal to block them from meetings or communications?
I didn't want to take over you guys. I'm trying to leave room. I know me, so but I have an answer, but I have no problem dealing with cantankerous association members if they don't abide by those rules we talked about, right? If you don't adopt those rules, then what are the standards? You have none. But if you have rules that, in short, act like an officer and a gentleman at all times, right? No cussing, no inciting a riot, that act like a gentleman, gentle lady, and you start yelling and screaming, I think you can abuse the right to be there. And when people are really cantankerous, I have no problem saying you're not welcome here anymore. For this meeting, for this purpose. And if necessary, have a police officer present, that sort of thing. I hate when you have to do that, but sometimes you do, and if they're not gonna, I hate to use the word behave, but if you're not gonna act like an adult, we have a business to run here. We got a $6 million, a $10 million budget. They're like little, these little companies. I like to call the associations corporations often nowadays, because it really is. It's a corporation. It's not just a family community association. This is a business. Just like a 7-Eleven's a business. We have to run that business. The board has to run the business. They need to be able to do that.
All right,
Yeah,
we've got about, go ahead. I'm sorry, Elizabeth.
I was just going to say we've on occasion had to write letters to unit owners who have made a consistent habit of disrupting meetings and laying down the law, so to speak, about what their participation is expected to be. And they cannot interfere with the business of the association because their disruption keeps the board from moving forward, and that's really impermissible.
But the members should know when they have the right to speak, and they should also know, and we're talking about this catch-all at the end of the meeting to say anything, And once the members know they get the right to speak and the board observes that, and then they get the right to speak at the end of the meeting and the board observes that, all of a sudden the need to interrupt, so much of the angst dissipates because now the member really knows they have this opportunity. They don't have to interrupt all the time.
Okay, now our rapid fire round. 5 minutes to answer 17 open questions. Let's see how many we can do here. Elizabeth, do the bill summaries that Travis alluded to have any legal authority? Does case law ever look to bill summaries as legislative intent where the statute isn't clear?
That's a very
bill- Yeah, the legislative intent can be discerned from some of the commentary, but it's typically not the bill summaries in my experience. The bill summaries really kind of outline what have been put in the bills. And Travis, please feel free to chime in on that use.
Yes, that is correct.
And it shows legislative intent in some circumstances. I've seen them used in court, but when the bill summary is talking about last year's legislation and whoever wrote it got it wrong, which is really what I think Barry is referring to in that inquiry, it's not really reliable.
Right, yeah, that's a staff member that writes those and not a legislator. So in court, simply then a letter from the actual sponsor or the legislature, or even answering of a question in committee, any proof of that regard, overrides that. That's
so what can we do then, Travis, from your perspective, right? We know in the bill summary for 1203, it says pooling of structural integrity reserves was not allowed, referring to present legislation, when in fact that's not addressed anywhere. It's an erroneous sentence. It doesn't belong there.
Right.
How do we get it out of there to alleviate this concern?
That's being looked at, and certainly I think will be addressed. These things can be updated and
nice. They can be updated.
Yep.
Oh, great. Good to know.
Travis, a quick one. My save Florida only for associations within 15 miles of the coast.
The condo portion of this, yes.
Okay.
Only within 15 miles of the coast.
How soon should board meeting minutes be posted after each meeting? Is there a time for that?
Not specified. Not specified in the statute.
All right. Can a community association state that pickup trucks must have a bed cover?
A good question.
I'm deferring to Bryony on that one.
Well, the new change in the law says that the homeowners associations can't regulate the pickup truck parking, but I don't know that whether or not one has a bed in a pickup truck is parking. It's not.
Right, and it would seem like a reasonable rule.
So the association could adopt a rule requiring pickup truck bed covers, yes.
And what we didn't talk about would be the applicability of so much of this, right? Because let's say we have an association, they say no trucks. Now this legislation says you can, and they don't have any type of Kaufman language, so incorporating the laws as they come out, if you will. So then is that association bound by it? And I think we're going to have all these disputes, procedural, substantive, and Kaufman and not Kaufman, as to the applicability of some of this.
Absolutely.
Well, that's a good point, Jeff. With regard to board member education, substantive or procedural?
Procedural.
Okay.
To me went quick. How about you guys? Procedural? Everybody?
Agreed.
You go.
All right.
Agreed.
Consensus.
On the
Tony, unfortunately, I have to drop off real quick, but appreciate the opportunity, but I gotta run to the airport.
No problem, Travis. Thank you
Thanks,
as
Travis.
always. We appreciate
Thank you
it.
guys, and we'll be in
work.
touch. Thank you.
All right, a couple more minutes. We'll get to a couple more questions. HOA parking and driveway section, just pickup trucks, or can we still restrict things like trailers in the driveway?
We can restrict semi-trucks. That is allowed. You can restrict semi-trucks. I don't see where you're granted a right here in this bill to park a trailer.
What about the
It's-
legislation that allows you to put anything on the lot, right? That is not seen from the frontage, adjoining, and now we have common area. Thank God they put common area in there as well, right? So now people can't put stuff in the backyard to annoy all their lake neighbors. There's some protection there.
But
All right,
if your
well,
trailer is not visible and it can be placed in their backyard, you can place any item, as long as it's not visible from an adjacent parcel or an adjacent common area or golf course.
Well, golf course, right? Golf course.
one more, hopefully quick one. For a condo board, is it required by statute to have a nominating committee, and who can be on it?
No requirement to have a nominating committee. There are some prohibitions. If you only had a nominating committee and didn't allow others to nominate themselves in a condo, I think that could be problematic.
All right. Well, listen, panelists, I'd like to be respectful of everybody's time today. We could go on. We've got some more open questions. We'll try to get to those after the presentation and get responses for you. We thank our attendees today, and certainly our panelists. Thank you for your time and your perspectives on this very active packet of legislation that the legislature has handed us. And as commented during the presentation, we'll wait and see, when they're presented to the governor, and ultimately what happens and if anything is vetoed. As part of FirstService's promise to deliver exceptional service,